Good evening. My name is Crystal Kessler, and on behalf of the Goldfarb Center for Public Affairs at Colby College, it's my pleasure to welcome you to the 2021 William R. and Linda K. Cotter Debate. The Cotter Debate series was established more than 20 years ago in 1999. It recognizes Colby's 18th president and his late wife, Linda, who was a cherished member of the Colby community. And we are so grateful this year to continue in their honor this wonderful tradition of debating the important public policy issues of our time. This year's debate addresses the following question: should Supreme Court justices have term limits? The appointment of 3 Supreme Court justices during the last presidential administration has created a significant ideological shift on the bench by cementing a 6-3 conservative majority, most likely for many years to come. This has brought renewed attention to the question of term limits versus lifetime appointments. While lifetime appointments were designed to ensure that the judicial branch maintains independence, some assert that instead term limits would lead to less partisan politics over vacancies and would help to preserve the independence and ultimately legitimacy of the court. Here to help us better understand the complexities of this issue are our 2 esteemed guests. Professor Suzanna Sherry joins us from Vanderbilt University Law School, where she is the Herman O. Loewenstein Chair in Law. Professor Sherry is a nationally recognized expert in constitutional law and has authored more than 100 books and articles, including recent pieces against Supreme Court term limits and on the need to decelebrify what she has called our Kardashian court. After graduating from law school at the University of Chicago, Professor Sherry clerked for Judge John Godbold of the U.S. Court of Appeals for the Fifth Circuit. She served as an associate with Miller, Cassidy, LaRocca, and Levin in DC, and she taught at the University of Minnesota Law School prior to arriving at Vanderbilt. Professor Sherry, welcome.
Thank you.
Ilya Shapiro joins us tonight from the Cato Institute, where he is the director of the Robert A. Levy Center for Constitutional Studies. Mr. Shapiro publishes the annual Cato Supreme Court Review and writes widely for professional, academic, and popular audiences. His most recent book, entitled Supreme Disorder, addresses judicial nominations, advocating for term limits, and explicitly addressing Professor Sherry's argument about decelebrifying the court. Mr. Shapiro also graduated from the University of Chicago Law School and then clerked for Judge E. Grady Jolly of the U.S. Court of Appeals for the Fifth Circuit. He served as a special assistant to the multinational force in Iraq on rule of law issues and has practiced at the law firms Patton Boggs and Cleary Gottlieb. Welcome, Mr. Shapiro.
Thank you.
And joining me also from Waterville this evening to moderate is Andrew Orntlish, Colby College, class of 2022. Andrew is a double major in government and economics. He has been involved with the Goldfarb Center throughout his time at Colby and is currently a co-chair of the Goldfarb Student Executive Board. Before we start, I will note for the audience that we'll reserve the last 15 minutes of our time together tonight for questions from the audience. So please feel free to submit those in the chat at any time throughout the debate. And without further ado, we're going to begin tonight with brief opening remarks from each of our guests, beginning with Mr. Shapiro. So I will, at this point, turn the floor over to him.
Thanks very much for that introduction, and thanks very much for inviting me. I haven't been to Maine that often, and while perhaps it's nice in certain respects not to have to go to Maine in February, but still, I do hope that once some sort of normalcy resumes, I can visit with you in person at some point. I'm actually in another cold place right now in Utah. My background is the Cato rooftop during warmer weather, but I happen to be out for a very short ski getaway and figured that rather than my very bland hotel room, you might like to see actually what Cato looks like. I happen to have gotten married on this roof deck. I can tell you that story later if you like. So I want to offer 2 cheers for term limits. In other words, I'm not a full-throated, term limits are the greatest thing since sliced bread and would fix everything that anyone thinks is wrong with the Supreme Court or America. But I do think it would be helpful and healthy. The death of Ruth Bader Ginsburg prompted once again a wave of discussion about the idea of limiting the term of Supreme Court justices. If only RBG had been forced to retire years ago, the theory goes, the country would not have faced a bitter confirmation fight in the midst of an already tumultuous election season. The hope, which first gained traction in modern times after Robert Bork's failed nomination in 1987, is that by more regularly replacing longtime justices with newer ones, adding predictability to when those switches occur, the nomination process would become less divisive and disruptive. I think that's largely right. Term limits could help restore confidence in the confirmation process and eliminate the morbid health watches we now have as justices age. But there are other problems they wouldn't fix. Now, during and after the Bork shutdown, the court was actually in a period of rapid turnover, I think six new justices in 8 years. And so term limits seem to be beside the point. But then after Stephen Breyer, who's much in the news now, will he retire, oldest justice, right? When he joined the bench in 1994 and no further vacancies arose for over a decade, the longest such period we've had in the modern age since we've had 9 justices, then the drumbeat for term limits grew. And that scholarship culminated in a proposal that's now celebrating its 15th anniversary, really. Stephen Calabresi and Jim Lundgren, who are 2 law professors at Northwestern, published the seminal article on term limits in the Harvard Journal of Law and Public Policy in 2006. You can look it up. Now, they argued for staggered 18-year terms, such that a vacancy occurs every 2 years in non-election years, giving each president 2 appointments per term. They also looked at different ways for enacting such a reform by statute and found them wanting, and so recommended a constitutional amendment. And I agree that a constitutional amendment would be required, which we can get into if you like. Now, the idea for limited judicial tenures isn't a new one, or something that started with Bork or Breyer or something like that. It was debated at the founding. Back then, the idea of lifetime appointments seemed the best way to establish an independent judiciary, insulating judges from political forces. But many now believe that the pendulum has swung too far the other way, with a court too reflective of past political fights and so unresponsive to contemporary realities. Even if these critics are wrong, if public perception is that the justices are out-of-touch ideologues, that isn't good for the Supreme Court or for the American body politic more broadly. If term limits were instituted, they would represent significant bipartisan consensus, given the difficulty of ratifying a constitutional amendment. Maybe there would be some horse trading, have term limits, but also limit the number to 9 or something. Who knows how that would work out, but that sort of consensus alone would indicate the resolution of many of the problems that term limits are being asked to remedy. But the reasons for growing public interest are clear, and I'll run through these very quickly. We can go back to it. First, the average tenure has increased significantly as a result of rising life expectancies, increased prestige of the job, and a reduction in the difficulties associated with service. So before 1970, you don't have to go back to pre-Civil War days or anything, but before 1970, the average justice tenure was less than 15 years. The average justice left the court, whether voluntarily or not, at 60 years of age. After 1970, so the last 50 years, the average tenure is 26.7 years, and the average age of departure is 79.6. And if you only look at the last 9 justices who departed, then that's even more than 28 years on average of service and 81 years of age at departure. So these things are growing. Life tenure enables justices to time their retirement for political purposes, which takes away from the idea that the court is detached from the partisan gamesmanship of Congress and the presidency. And third, the longer justices serve, the less accountable they become to democratic sentiments and the more independent they're perceived to be from the cultural zeitgeist that inevitably informs the public's response to the court's rulings. Now, 18-year term limits will not address all concerns. People are concerned that the court is too powerful or that the federal government is too powerful, forcing the court to rule on so many issues. This changes none of that. And 18 years is a long time anyway. We would still battle for those important seats. Yes, it's less than 30 years, but 18 is still significant. But it might be worth trying, even if it's not a panacea. As UC Berkeley law professor Orrin Kerr put it, if the Supreme Court is going to have an ideological direction, which for better or worse, history suggests it will, it's better to have that direction hinge on a more democratically accountable basis than the health of one or two octogenarians. So the best argument for term limits is really that they would make the Supreme Court more of a standard issue in presidential and Senate campaigns and less of a political football when the winners of those elections get to nominate and confirm justices, moving politics to the political realm and maybe keeping law and jurisprudence to its realm. So thanks very much. I look forward to the more discussion.
Thank you. And we will turn now to Professor Sherry for her opening remarks.
Thank you, and thank you for inviting me. Ilya is a formidable opponent, but I hope to convince you that he's wrong on term limits. In order to understand why term limits won't fix what's wrong with the Supreme Court, we first have to understand what is wrong with the Supreme Court. What are the problems? I disagree with Ilya about both the increase in tenure length and strategic retirements being problems. There are other studies that suggest that there have not been very many strategic retirements, or at least if there are, they don't work very well. Very few justices, very few seats on the court have remained in the hands of one party more than two justices in a row. As for the increase in tenure length, length of tenure, some of that is a manifestation of where you break the statistics. So if you say before 1970 and after 1970, yes, you see a significant rise in the length of tenure, but if you break it by decade, starting in the 1780s, you don't see so much. It's up and it's down and it's up and it's down, and it's not a significant rise recently. It's also not, the problem is not that the court is counter-majoritarian or out of step with the popular will. According to the founding generation and the genius of American constitutional democracy, the court is supposed to be counter-majoritarian. It's supposed to act as a brake on the popular branches and prevent a tyranny of the majority. Short-term popular desires often conflict with the more durable principles that are enshrined in the Constitution. So a court that's overly responsive to a fickle and easily manipulated popular will makes a written constitution useless. No, the problem with the court is twofold, and the two parts feed on and exacerbate each other. First, presidents and senators, especially, although not exclusively, Republican presidents and senators, are trying to take what was a previously independent and largely non-ideological entity and capture it, and they're trying to politicize it, to harness it for ideological reasons. Second, and this is something that Ilya mentioned that I have recently written about, the justices themselves have become celebrities. And not just celebrities, but politically polarized celebrities who play to their ideological fan bases. They give political stump speeches to the Federalist Society or to the American Constitution Society. They write political books. They appear on TV and in movies. That celebrity increases the public perception of the court as ideologically or politically motivated. It also leads to a dysfunctional court that can't deliberate or compromise. So we get cases that have no majority opinion, or we get cases where justices write separate opinions to telegraph how they will vote on issues that are actually not before the court. And all of this is in order for them to keep faith with their polarized fan base. Term limits will not solve either of these problems, and it may well make the first one, that is the confirmation problems, worse. Many proponents of term limits, including Ilya, seem to think that regularizing vacancies would reduce the stakes of appointments and de-escalate the appointment process. I think it would do exactly the opposite. For one thing, it would make the Supreme Court an issue in every presidential election, further politicizing both the nomination process and the court itself. And it's naive to think that senators who have been willing to play constitutional hardball will suddenly be more accommodating if every president gets two nominees. It's much more likely that a president facing a Senate majority of the opposing party will be stymied. He or she either won't be able to make any appointments at all, or will be forced to nominate justices who are friendlier to the Senate's party than to the president's. In particular, do we really believe that the same Republican Party that claimed that 10 months before an election was too close to allow a hearing on a Democratic nominee, but then rammed through a Republican nominee mere weeks before an election, that confirmed a nominee against whom credible allegations of sexual assault had been made without so much as an investigation, and that confirmed a Catholic nominee who had written that when the laws of the church conflict with the laws of the country, a Catholic judge must follow the laws of the church? Do we really believe that that—
She actually said the opposite, but that's a separate issue.
Do we really believe that that Republican Party would meekly allow a Democratic president to appoint, for example, a pro-choice, anti-gun separation of church and state liberal? In addition to making confirmation battles worse rather than better, term limits would have at least 3 additional deleterious effects on the court. First, it's likely that a president, knowing that his or her appointees were term limited, would make the most of each appointee, nominating the most extreme candidates. And the justices might well act accordingly, making the most of their short time on the court. Second, given life expectancies, term-limited justices would probably want to continue working after their tenure on the court. Justices with one eye on their future employment, however, are less likely to be independent and impartial. Would a justice who hoped to end up in a big firm rule against business interests? Would a justice who planned on a subsequent academic career be neutral when university interests were at stake? Finally, at least one study has suggested that term limits would reduce stability and predictability in law, as precedents would be more frequently overruled. I don't know exactly how to fix the problems of polarization and politicization, but I do know that term limits are not the answer. Thank you.
Thank you both so much for those wonderful opening statements. I think just starting off, I think a fundamental difference in both of your perspectives is the ideal of the court and whether it should be more reflective of current politics versus, as Professor Sherry pointed out, a counter-majoritarian force. So I guess for both of you, starting with Ilya, is this ideal something that we should strive for, and why are term limits the best mechanism or the worst mechanism to achieve that ideal?
Yeah, I don't want people to get the wrong idea. I agree the court is and should be a counter-majoritarian check. I wish it was more of one. I wish more laws, both federal and state, were invalidated because I have a very robust view of the Constitution's protections, both for individual rights and the limits of the federal government. So I wish the court were more counter-majoritarian. But historically, the court never gets too far ahead or behind public opinion because the justices themselves think about their own legitimacy in that way. Yeah, that's all I'll say on that. I mean, term limits, I think, probably won't affect that one way or another. They'll simply kind of update the court in a way that people, to the extent that a lot on the left, especially, because a lot of Suzanna's critique was from the left, a lot on the left who critique the court now see it as illegitimate for precisely not reflecting old, the dead hand kind of thing, and not reflecting modern political debate. Well, term limits could solve that by bringing in newer justices.
I agree that the left does not like the current court. And a lot of people who were in favor of lifetime tenure and in favor of a lot of liberals who were 20, 30, 40 years ago in favor of lifetime tenure and in favor of, for example, judicial activism have suddenly switched sides. People who were conservative have also switched sides. The liberals who loved the Warren court now hate the Roberts court, and vice versa, even if both are equally activist. In terms of counter-majoritarian, I can't can't do much better than to quote Alexander Hamilton, obviously one of the founders in the Federalist Papers, and Alexander Bickel, one of the foremost modern scholars of the court. Hamilton said, life tenure is the best expedient which can be devised in any government to secure a steady, upright, and impartial administration of justice. Nothing can contribute so much to the judiciary's firmness and independence as permanence in office, and may therefore be justly regarded as an indispensable ingredient in its constitution, and in great measure as the citadel of the public justice and the public security. That's Hamilton. Back in 1787. And here's Alexander Bickel in 1962. The court's insulation and the marvelous mystery of time give the courts the capacity to appeal to men's better natures, to call forth their aspirations, which may have been forgotten in the moment's hue and cry. And he quoted Justice Stone as this being the opportunity for the sober, that is the court being the opportunity for the sober second thought. I think given our politics, we really need an institution that stands back from it and gives everything a sober second thought without being influenced by popular will.
I agree with that sentiment, actually. And I alluded to Hamilton's writings in my opening remarks, but popular percent, I mean, I'm arguing for term limits, not for me, because I don't have a problem with the court as it is, but I think a lot of people do. And to enhance its popular legitimacy or acceptability, I think term limits would be popular and would see the court as if it would make the court seem less political to have term limits, which it might because of the regularity and all of that, then it's worth doing. But it's not for me. It's not that I'm saying I have a problem with the court that the term limits would solve. The broader issue, and this gets into some of the other things that Suzanna said, and perhaps we'll get this into other questions, is that politics has always been part of the process. And I don't want to, buy my book, Supreme Disorder, Judicial Nominations and the Politics of America's Highest Court, right? George Washington had a nominee rejected. So many presidents have had different troubles of various kinds. What's changed isn't that politics, senators, presidents are acting like politicians. I'm shocked. What's new, and really in the last 50 years or so, I point it to 1968, not even Bork, I point it to 1968, a pivotal year in American history for many reasons, is that we now have divergent interpretive theories that map onto partisan preference at a time when the parties are more ideologically sorted and polarized than they've been since the Civil War. That's different, and that's the source of all our tension. So the term limits is not going to fix that, which is why I have two chairs, which is why I said it's not a panacea. I'm just saying, as a public confidence building measure, if more people are going to respect the court, then great.
But see, I disagree that it will legitimize, that term limits would legitimize the court. I think it would make it worse. That is, because there would be a confirmation hearing every 2 years, and because therefore the Supreme Court would be as part of the presidential agenda during campaigns, it would constantly be a refrain of, I will appoint conservative justices, I will appoint liberal justices, and then there would be the battles in the Senate over how conservative or how liberal, and it would simply confirm to the public that, well, these are just, the justices are just legislators in robes, they're making it up as they go along, there's no law there, it's all politics. I think what we need to do is try and somehow step back from that. I have some possible suggestions. For example, if we required a 2/3 majority for confirmations, it would make confirmations more difficult, but we might get more compromise candidates, more centrist judges, and perhaps reduce the polarization on the Supreme Court. The other thing I would like to do is sort of push the justices back into obscurity so that they're not household names, so that they're not celebrities, so that the confirmation hearings aren't what everybody watches on television. I don't know how to do that.
I do, and it's not easy and it's not quick. And that's overall to make the court less important. And how do you do that? By enforcing federalism and separation of powers. So push back, over decades, this is not, since Bork or since Thomas or anything like this. but over decades going back to the New Deal and before, there's been a centralization of power in Washington, and within Washington, a skewing of that power towards the executive branch, a growth of the administrative state. And so the court ultimately has to make decisions for a large pluralistic society that are kind of one size fits all. Instead of letting Texas have its own health policy and California have its own health policy and Maine, doing its own thing on so many issues, other than those that are truly national. Now, if the Supreme Court were only ruling on, kind of more obscure things, not these all important world historical, Obamacare this and all of that, then people would care less and the justices would be less celebrities. Now, you can't get rid of that altogether because there'll still be debate over fundamental individual rights and interpretations of speech and gun rights and abortion rights and things like that. But still, letting separation of powers and federalism work its way more strictly, I think, would decrease the momentous decisions that the court would have to take and increase those that Congress and state legislatures would, which is where we're supposed to hash out our political differences.
Except most of what the public follows, Obamacare accepted. Obamacare is probably the Affordable Care Act is probably the only modern or one of the very few modern issues that is about either federalism or separation of powers or the power of the government, the power of the federal government. Almost all of the other things that the court does that people care about are individual rights of all sorts, everything from abortion to gun rights to affirmative action to the rights of criminal defendants to gay rights. All of that would still, in your view, be appropriate subject for the court because it is individual rights. And I agree with you on that. I think it is very important for the court. That's the most important thing that they can do. But I don't think most people care very much, other than the Affordable Care Act. Most people don't know or care very much what the court does in the areas of federalism and separation of powers. So I don't think that stepping back from that would help.
Thank you both for that lively conversation. Now moving on to potential consequences of implementing term limits. Professor Sherry, I know a lot of your research has touched on this, specifically on Roe v. Wade and hypothetical rulings. So just now I'd like to ask about, I guess, what a 18-year term limit court would look like in terms of judicial rulings and I guess potential consequences. I know we've touched upon the nomination process, but what that would look like.
That's a really good article. Everyone should download and read Suzanna's article on term limits and Roe v. Wade as an example of instability of precedents.
Well, thank you. The article is called Term Limits and Turmoil, and it is co-authored. My co-author, Chris Sunby, was a former student of mine, and he is fabulous. And he did all of the computer simulation for that article. What that article did was to assume that term limits were in place when Roe v. Wade was decided in 1973, and that the first most senior justice, who then would have been Justice Stevens, was due to retire under the term limits in 1975. And then we took the real Senate and the real president every 2 years, and we did what are called Monte Carlo simulations. That is basically, we assigned probabilities. What's the probability that a Democratic president with a Republican Senate would successfully nominate a justice who would support Roe or a justice who would want to overrule Roe? What about if it was a Democratic president with a Democratic Senate? What about a Republican president, and so on? And then we ran these simulations. If, for example, we said there was an 80% probability, we ran it enough times that 80% of the time, that 80% probability would come out. And we did that for every 2 years until through 2019. That is through what would have been President Trump's second appointment in his first term. We did this, we didn't know at the time, of course, whether he would have another term. And we found that Roe most likely would have been overruled sometime in the 1980s. It would have been reinstated, that is, abortion rights would have been protected again sometime in the late either 2000s or early 2010s. And then it would have been re-overruled with the appointment, with President Trump's second appointment in 2019. And so that we suggested that was just unacceptable unacceptable stability. I do have a second point about consequences, however, beyond the instability. I think that to the extent that I believe it was Crystal mentioned, that term limits have gotten some more play these days because people are worried about the three Trump appointees cementing the conservatism of the court. I think that term limits would actually end up guaranteeing us a more conservative court generally. And I think Ilya might like this. I would not. And the reason is that it gives the Senate the opportunity to block the opposing party's nominees every 2 years. That is, it's not just sort of random, it is every 2 years. There are studies that suggest that 60% of nominations since 1937, had there been term limits, would have changed the ideological composition of the court, and that between 62 and 75% of the nominations would occur when the president and the Senate are of different parties, right? If it's random, you can't predict that. If it's every 2 years, you can predict that, and they did this based on history. And so that does give the Senate a lot of opportunities to block an opposing party's nominees, and I believe that the Republicans would do so more, both because they are more willing to play constitutional hardball, and they are better at it. The Democrats just don't seem to be very good at constitutional hardball. But there's also a structural reason, which is that we're only going, if we have divided government, if there is a president and a Senate of different parties, it is almost always going to be a Democratic president and a Republican Senate. It is in our polarized times, it is very rarely, if ever, going to be a Republican president and a Democratic Senate. Why? Because the Senate with 2 senators from each state is more biased in favor of small rural states. That is, the rural states have an outsized influence in the Senate. For example, in today's 50-50 Senate, Republicans represent only 44% of the population, even though they are 50% of the Senate. So the Senate is likely to be more Republican than the president is, since the Electoral College takes into account not just the Senate, but the House, which is a little more democratically divided. So I think it's just going to cement a conservative majority.
Well, I mean, we can do Monte Carlo simulations about all this, but fundamentally, the populace changes. It's very hard to make predictions, especially about the future, as Yogi Berra would say, and all this calculus isn't necessarily true. The one thing that Suzanna said that is important is that there's a huge difference with Supreme Court nominations during times of divided versus united government. In our history, there have now been 164 nominations. The overall success rate is 77%, 127 of 164. But during times of united government, meaning Senate, White House, same party, that's about 90%. And during divided, we're under 60%. And that's accentuated even more, by the way, during presidential election years, which we've now had vacancies in 2 consecutive presidential election years. During divided, there's a confirmation 20% of the time, during united, 90% of the time. So how this would work in a term limit system, there are ways, since we're doing a constitutional amendment anyway, you could put other things in there, like, if the Senate can only reject for so long, or fundamentally, there could be a political check in the sense that the Republicans held the Scalia vacancy open for 11 months, but could they really do that for 2 years, for 3 years, for 4 years? Would the voters back them up in that case? I don't know. There's been an escalation, a tit for tat escalation going back decades in our judicial battles, and neither party's hands are clean at this. I don't think Republicans are necessarily better. I don't think they're necessarily worse. It's just different times and different situations and different actors and what have you. But it does introduce an interesting dynamic. One thing that I will say is that if a nominee, if a term, I mean, you could work this, that if a nominee is blocked or the president makes a nomination and nobody's confirmed, then either the president of the next party doesn't get to fill it or gets to fill it for fewer years or something. You can twiddle with trying to resolve those sorts of issues, but I don't think the divided versus united government issue is going to be more contentious than it has been already in our history.
I think there's something to that, and I agree that the real problem is the polarization in the political parties, and I just don't think the Supreme Court plays a very large role in that, and I don't think that changing to term limits is. I mean, you seem to agree that changing to term limits isn't really going to help.
Look,
that.
all of these reforms, whether term limits, whether the decelebrification, whether changing the rules for confirmations, all these things, I go through them in my book. It's all kind of nibbling around the edges. It's all rearranging deck chairs on the Titanic. So the Titanic is the ship of state. You know, politicians respond to their political incentives. And as I said, what's different now is not just the polarization of the parties, that's different, but also divergent interpretive theories. You know, it wasn't always the case that you had, you know, it wasn't always originalism versus living constitutionalism, but different theories of law would map onto partisan preference. That's a new thing. Or for that matter, that judicial philosophy itself would be the key determinant of how people thought about, how presidents thought about nominations. That's an innovation with Richard Nixon, who campaigned against the Warren Court with a strict constructionism. Because otherwise, it would be, you know, different things, placating regional interests, or one key issue, be that slavery, be it industrial era regulation, executive power in wartime, be that the Civil War or World War II. You know, that was the overriding issue, and nominees differed on all sorts of other things, and they differed on what the political. So anyway, these modern developments kind of make historical comparisons inapt in certain respects.
I agree with you that there is this divergence in interpretive theories, but I don't, and I agree that at least on the surface it appears to map onto political divisions. That is, that liberals are living constitutionalists and conservatives are originalists, except that conservatives are not consistently originalists. Justice Scalia, who was one of the most vocal originalists, completely ignored the original intent and the constitutional history when it came to First Amendment issues. Now, I happen to agree with almost all of his First Amendment positions. I think he was correct on those, but they're not originalist. And he didn't even pretend that they were. He didn't even look at the history. When it came to something like gun rights, in his very long Heller opinion, which went through the history ad nauseum about what the Second Amendment meant, and why it meant that you couldn't ban handguns, he said, offhand in one paragraph, but of course you could prevent felons and the criminally insane and various other people. You could regulate it in some ways. In that paragraph, not a word about whether that was historically backed up. That was just his view. He thought that was right. So I think that at least originalism is a cover for conservative policies.
Well, I disagree with that. I do agree that there's a lot more unpredictability on the right side of the court than on the left. I had a piece, I think, in USA Today about 2 years ago about how the Ginsburg Four are really the bloc, not the Roberts Five, which disagree in various ways at different times. But that's a whole separate other debate.
It is indeed.
Yeah. Moving on, I think, to our last topic before we get to audience questions. Ilya, you've mentioned the constitutionality of implementing these term limits. Why is that the only way to implement them? And of course, a constitutional amendment is pretty politically infeasible. So are there any alternatives, or is that the one way to get this through?
Yeah, I mean, the proposal, which is backed by some academics, but certainly it has support among House Democrats, is to say that the key constitutional provision at issue is that federal judges are supposed to serve during good behavior, which everyone agrees means for life, and you can't diminish their emoluments, meaning their pay, their benefits, all of that sort of thing. So the proposal is the most senior justices become called senior justices, and they keep their pension, they keep their salary, they keep their chauffeur, whatever it is they get now, they still will have. But they rotate off the court, and someone new can get on. And perhaps this is a corollary, not absolutely necessary. But if someone's recused, maybe then the senior justices can fill their slot for those particular cases or something. It's clever, but again, I don't think that satisfies the constitutional requirement, because you are diminishing the office. It's being a senior justice and hearing cases rarely, if at all, is different than the office of hearing Supreme Court cases. So I do think it would require an amendment. Now, I think constitutional amendments shouldn't be thought of as these things that are only reserved for, I don't know, abolishing slavery or allowing women to vote or something like that. I think it's unfortunate that because we had a lot of sub rosa or implicit amendments during the New Deal and otherwise, that we now come to think of amendments as just, beyond the pale. But maybe there's, stranger things have happened in our politics in the last decade, so who knows?
For once, I agree completely with Ilya about the constitutionality. I think that it is very clever to try and get around it, but I don't think that it would be upheld as constitutional if you say to justices, well, you get all the pay and everything else, but you don't get to judge. That's not a judge. And I think that, and of course, it's not clear who would decide the constitutionality of such a statute. But I don't think any federal judge, whether Supreme Court or lower court, would uphold the constitutionality. I do disagree about amendments. I mean, I agree that they should not be thought of as very rare. I mean, if they're needed, they're needed. They are very difficult, is what they are. But on the other hand, if the polls are correct, very large numbers, bipartisan numbers, support term limits. And so it might well be that this constitutional amendment could pass. I would prefer a constitutional amendment to a statute, even if it were statutorily possible, both because that means it can't be undone very easily, and because a constitutional amendment takes time and thought. And therefore, it would not be a spur of the moment, oh, everybody's all up in arms about Justice Ginsburg and Justice Breyer or whoever it is. Let's pass term limits. I would rather see it, okay, it's going to take us a couple of years to get this put before the states, to get the states to ratify it. We'll see if the momentum keeps up.
Great, thank you both so much. And I'd like to turn it over now to Crystal with some audience questions for you both.
Great, yeah, so I have the pleasure of fielding a number of really excellent questions from the audience. We're going to start with one that is, seemingly a little bit similar to term limits, but could very well be quite different, and that is some sort of age limit. So someone in the audience asks, how each of you would feel about age limits on Supreme Court justices, and if you would be in favor of them, what might that policy look like?
I think age limits on the back end, that is that you have to retire at 75 or whatever, would essentially be like term limits, except that the one thing it would do is that it would, the bad thing it would do would be to encourage presidents to appoint younger and younger justices. So in some sense, it would be even worse than what we have now, or than what we would have under term limits. On the other hand, I would support a minimum age for justices, and I would put it quite high, like maybe 60. Which is what basically, until recently, until the last maybe 30, 40 years, presidents appointed justices who had lived, who had had experience, who had practiced law. They appointed justices who'd been in legislatures. They appointed justices who'd been in state politics. None of that anymore. Now we take people, they maybe have a little bit of practice experience, usually not much. They go into a federal agency, then they become a federal court of appeals judge, maybe with a district court judge in between, but usually not. And then they go on the Supreme Court and they're very young. And so I think that's a bad idea. We have minimum ages for Congress, for the Senate, for the president. Why not have it for the Supreme Court?
Yeah, I think that a maximum age is inferior to term limits because for that reason, it would incentivize younger and younger appointments. Term limits, on the other hand, would incentivize, all of a sudden people in their 60s would become viable candidates, or at least mid 50s. The last person, so Garland was nominated, he was 60, but that's a rare case because that was Obama's attempt at a compromise. But otherwise, it was Ginsburg nearly 30 years ago who was 60. Otherwise, we haven't had any nominees even over 55, any successful ones. I think Harriet Miers was 55 or 56.
Sotomayor was in her mid 50s. Am I incorrect about that?
She might have been 52 or something like that, but nobody over 55. So, has all the disadvantages of term limits, but I think, yeah. inferior.
So, just a quick follow-up, and this is actually sort of from the same person who was asking about age limits, is Professor Sherry, you sort of mentioned that, push it, judges who are too young and don't have enough experience, if this is a bad thing. I was just wondering if you could speak a little bit to just general, sort of evidence that you might have about effectiveness of judges at different ages, because this audience member was sort of wondering about that. I mean, what's your particular concern with judges who are younger?
I don't have any particular evidence. I haven't studied it. I just know from personal experience and from everybody I know that people learn as they get older. They do a better job at whatever it is that they are doing. And the more diverse experiences you have had before you take on a job like Supreme Court Justice, I think the better. I am sorry that we've lost a lot of diversity on the Supreme Court. Now, we've gained some kinds of diversity, but we've lost diversity of experience. And I mean, until Justice Barrett, all of the justices had attended either, sitting justices had attended either Harvard or Yale for law school.
So
again, before
clearly the ultimate solution is to have more University of Chicago alumni on this.
Well, yes, I would support that, but that's a different story. But it's not just about where you went to school. Something like, I think it was, again, this was, I did this study before Justice Ginsburg died. All but 2 of the justices had been born in what the territories that had made up the original 13 colonies. None of them had legislative experience. None of them had experience in state government. None of them had serious private practice experience. This is a loss.
I agree with that. I don't think it's tied to age, however.
No, I think it's a different.
It's kind of a professionalization and a nationalization of legal credentialing and things like this. But you're right. Justice Kagan is the exception. She was not a judge. She was merely Solicitor General, often referred to as the 10th
But she was
Justice.
nominated. She was
nominated to be a DC Circuit judge. That's right. Yeah, you don't have any more. Well, Sandra Day O'Connor was the last state jurist. We haven't had a senator
Justice Black
since the 50 or the 30s, I forget. Yeah.
Justice Black was the last, and he was on until the 1970s.
Right. The last one nominated, I think, was Sherman Minton in the 50s. But anyway, yeah.
Great. Next question. So changing gears completely here. Someone in the audience is wondering about the issue, the kind of problem that happened basically with the Merrick Garland case, the idea that the Senate can block even a hearing for a nominee. And I'm wondering, and this audience member is wondering, sort of how that, could that be, I mean, is that completely independent of the issue of term limits, or is there something in thinking about a new policy of term limits that would, improve that issue, make that issue worse?
Well, with term limits, there wouldn't be presidential election year vacancies. So to that extent, it wouldn't have that kind of issue. Garland was not unprecedented. I mean, especially in the 19th century, we had lots of nominees not acted upon in various ways. There was a great Senate procedural euphemism called postponed indefinitely, right? It's great. The thing is that the presidential election year nominations, vacancies, don't happen that often, and they're exceedingly rare during times of divided government because it has to be a death. Nobody's going to retire otherwise because they're politically savvy. And so the last time there was a confirmation to an election year vacancy was 1888. So it's not surprising that Garland was not ultimately confirmed, whether without a hearing or, I mean, hearings didn't start till 1916 anyway, and the nominees didn't regularly start testifying until the 1950s for assorted other reasons. But yeah, I mean, the only thing that's relevant to with term limits is that it's an attempt to get rid of the arbitrary vacancies and have regularity and more focus on, hey, it's not just when there's a vacancy that you have to think about the presidency and the Supreme Court at the same time. It's every presidential and every senatorial election.
I do want to correct one thing. The last time a nominee was confirmed in in divided government in an election year, you're right, might have been 1888 or whatever he said. But the last time a nominee in an election year was confirmed was just a few months ago. Just a few weeks before an election. I agree that I'm not sure that whether it's an election year or not matters. There will be divided government, and there will be presidents appointing, nominating justices who the Senate doesn't like. And then the question is, can they just refuse to hold a hearing? Can they just turn down one nominee after another? And there, Ilya suggested that maybe that could be worked out in detail about, what they're allowed to do and what happens if they don't give a hearing, or that they don't accept 3 nominees in a row or something. I think that putting that in something like that in a constitutional amendment would be a serious mistake. Constitutional amendments should not be that granular to figure out, well, what happens if the Senate in one of the president's nominees just doesn't act? That would take a statute, and I am not confident that this Congress, this polarized Congress, could get together to enact this, even if we had term limits under a constitutional.
But again, I think the political solution is there. When Bork was rejected, ultimately somebody was confirmed. Kennedy. Well, Ginsburg had to withdraw. As I called Douglas Ginsburg the last public casualty of the drug war. I can't think of any other public official in the last 30 years whose career suffered for the disclosure of drug use. But anyway, and then Kennedy, who was kind of a compromise pick, ultimately was confirmed because Reagan didn't have any more political capital. And the same thing could happen in reverse. Could the Senate really hold a seat open or keep rejecting, perfectly good, not someone who could be characterized as, radical, to the extreme left of the Democrats or to the extreme right of but kind of someone from the mainstream left, the mainstream right. Could you just keep on rejecting those? At a certain point, voters are going to are going to clear that jam.
Maybe.
So next question. Obviously, one of the other questions on the table in the last year has been the number 9 and whether that's the right number of Supreme Court justices. Is there anything about that issue that we might want to think about in tandem with the issue of term limits?
Well, the first thing to note is that this does not take a constitutional amendment. This is specifying how many justices there are on the Supreme Court is totally within Congress's discretion, and it's been as low as 5 and as high as 10. And they have, in fact, added justices right after the Civil War. Right after the Civil War, I guess they added a 10th justice and then shrank it back down to avoid giving the president any more nominees. So that's something that Congress could do. I have always been opposed to expanding the court that way because I think that it is open for retaliation. I mean, basically, the Democrats get in now, they expand it, then the Republicans get in and they expand it, and eventually we have a completely unwieldy Supreme Court. When the Republicans rammed through the confirmation of Justice Barrett, I changed my mind, and I think that it is now appropriate, given the hardball that the Republicans have been playing, I think it is now appropriate for the Democrats to play a little bit of hardball and expand the court. Even if it does invite retaliation.
I remain in agreement with Bernie Sanders on this question, possibly the only thing on which I agree with him, where he said exactly what Suzanna just did. I'm not in favor of court packing because then the Republicans will add 2 more, and in 50 years, I'm not going to do the accent, but he said in 50 years we're going to have 87 justices. It's crazy. And in our history, until 1869, when it was fixed by statute at 9, every expansion, contraction, there's been some political shenanigans involved, not to the benefit of the country. So there's nothing magical about the number 9. At this point, it's just a 150-year-old norm. If we were creating a Supreme Court from scratch, maybe you'd have 15 because there'd be fewer 8-7 decisions than there are currently 5-4, and each one of 15 seats is less valuable and therefore less contentious than each one of 9. Or maybe you'd have an even number. Some countries have an even number of high court justices, so you'd need a margin of 2. But anyway, these things are political scientists talk about them, but we're not writing on a blank slate, and so it's impossible to divorce that question from the transition and the politicization.
another sort of logistical question. I think this one mostly goes to Ilya because it's, involves supporting term limits, and that would be what would happen to current sitting justices. I don't think that's something that's come up.
Yeah, there is a law review article. I forget. It's not the Calabresi-Lindgren one. It's another one that games all this out. Basically, they have to by the Constitution, unless you had the constitutional amendment that curtailed their own constitutional terms, which would be controversial. So they would serve out their natural terms until they retired or died, and otherwise you would have openings in the regular pattern. So it plays itself out, but it's a transition issue. It gets a little messy at a certain point. Do you write it in such a way that you keep having a vacancy every 2 years, and so the court could have, if all of the current justices each lived another 18 years, could you have an 18 justice court? Probably not, but this might have that kind of transition issue might have to be written into the constitutional amendment, but it is something to contend with.
Final question, I think we're getting down to the wire on our time, is about this issue that I think Professor Sherry, you raised about, one of your concerns if justices had term limits would be, they would be thinking about what their post-Supreme Court career would look like. And an audience member wonders whether the justices are compensated so well, or perhaps whether they could be, that they would choose a senior inactive role over private industry. So
compared to what they could earn in big law, or probably in a think tank, or even in academia, no, they are not paid very well. All of our judges are.
I don't know what Vanderbilt Law School pays, but think tank constitutional lawyers, or you're not going to be that's not in the same ballpark as big law or anything like that.
No, it's not in the same ballpark, but imagine the think tank that could nab a former Supreme Court justice. They'd be willing to pay that person quite a lot. Yeah. One further point on that, there have been studies, obviously not of Supreme Court justices who leave the court and then go on, but of legislators, federal legislators and Capitol Hill staffers, and who are either term limited or, well, I guess not term limited, but who know they're leaving for one reason or another. And the studies suggest that their behavior in their last year or few years of duty does change when they know that they're not going to be staying on the Hill. And so there's no reason to expect that the justices would be any different. They might not change until their last few years of their 18-year term, or they might figure, well, I'm going to be in the public eye the whole time, and they might keep their eye on the future career the whole time.
I share that concern for everyone except justices. I think lower court judges should not be term limited. I don't like elected judges because they're currying favor in all sorts of ways. For politicians, it doesn't what Suzanna just said about the politicians' behavior, but also the lobbyists and the bureaucrats and the staffs aren't term limited, so that just leads to capture by other interests. So it doesn't do what people who advocate legislative term limits want. For justices, especially if you had with term limits, presumably these would be people who are in their mid-50s being appointed, or even 60, as we just discussed. This would be their capstone job. Maybe they would serve on a corporate board after that, or something, maybe something honorary. But another thing could be that you pass a statute, yeah, sure, giving them $1 million pensions. There's only 9 of them. It's not like it's going to bankrupt anybody. In our history, we have solved a lot of issues in the organization of judiciary by increasing judicial pensions. It's uncanny.
Great, thank you. We've unfortunately come to the end of our time tonight. So I want to take this opportunity to offer my deep thanks to both of our guests for this incredibly stimulating debate. I know it has given all of us a lot to think about right now tonight, and has also inspired us all to continue to think about these issues from a variety of perspectives. We're grateful to both of you for taking the time to help us better understand the complexities of this issue. And of course, we're grateful to everyone in the audience for joining us tonight. Good night.